I'm attorney Palmer Johnson. Welcome to my video series where I address some of the most frequently asked questions I get from family law clients. Remember, my responses to each question are not meant to serve as legal advice and are not a substitute for speaking to a licensed attorney about your specific situation. Today's question is, how do you prove substance abuse during a divorce in Oklahoma? So, substance abuse is a growing problem and continues to plague lots of people, but it's a huge contributing factor to the breakup of a lot of divorces. The problem can be, how do you prove that in court? So we're going to run through just a couple of different things that can be very helpful tools. Arrest reports. This is typically really compelling evidence when someone's substance abuse leads to them being charged with a crime or arrested. We can certainly use that in court. Witness testimony. If there are key people who can testify either to having personal knowledge of witnessing substance abuse or personal knowledge of the effects that substance abuse has had on this individual, we can bring them in to testify. Failed drug test. This is a pretty obvious option. We can ask the court to order a drug test, and if the results come back positive, well, we've got our proof right there. And then the final thing is to take those different factors and tell a story and show how that impacts parenting and affects the children, and use that to tailor what would be an appropriate custody arrangement and visitation, from the most restrictive to something intermediate, and what kind of efforts are being made by the substance abusing party to clean up, correct, or address those issues. If you need legal advice on this topic or help with a different family law matter and you live in northeastern Oklahoma, contact me at Moms.Law to schedule your low-cost personal consultation.